From a clip there in the Jeffrey Willis trial, we're going to go live to that courtroom at 2 p.m. Kevin Bloom is expected to take the stand. That's, remember, Willis's cousin, and that's expected to start at 2 p.m. to begin the defense case in that trial. But right before that, we quickly showed you guys the Tiger Woods hearing out of Palm Beach County, Florida. And in that hearing, we saw Tiger Woods there. The DUI charge was dropped against Woods. He pleaded guilty to a reckless driving charge, which is a lesser offense, and he's been now placed on probation for 12 months with a $250 fine. I don't think he'll have any trouble paying that. There are conditions, however. He will have to donate, again, $200 to PBC Victim Services and enroll in a treatment program, which includes 50 hours of community service. And he will have to live without a car for 10 days. He will be immobilized, essentially. So that in exchange for the count of the DUI being dropped against Tiger Woods. So pretty interesting information there. Until that time, the judge told him that he could be sent to jail for 90 days if Tiger Woods violates his probation. So all eyes will be on Mr. Woods now for the duration of this time period in which he cannot violate this probation, or he could be sent to jail for 90 days, which would be quite extraordinary. Coming up, guys, at 2 o'clock, we're going back live into the Willis courtroom, audio only. I'm joined here with Norman Willis, defense attorney, one of our favorite guests here at LawNewz. Thanks for being with us, Norman.
My pleasure.
So now, right before we came on, we were listening to a soundbite that actually had to do with Jessica Haringa's disappearance. Remember, she's not the victim in this case. She's a previous victim of this defendant's. He has not stood trial for her murder yet. But I want to talk a little bit about how prosecutors got this evidence in the first place. Remember, if you watch LawNewz a lot, we hear everybody tell you that prior bad acts are not allowed in specific discrete cases. Why are we hearing this now?
Right. Well, there is one instance in which prior bad acts can be used. In New York State case, People v. Molyneux case says that you can use a prior bad act to show that a person didn't make a mistake, that this is something that they've done before. You know, you can use it to show that their intent in the situation. So there's about five limited categories where prior bad act evidence is admissible, and if it doesn't fit those categories, it's just out. Right.
And as a defense attorney, you know, I want to say, oh, that evidence should be kept out. But as just a normal citizen, I'm very glad that it was brought in, because I think this guy is guilty. And I think that, you know, as defense attorneys, I think we know the truth behind prosecutors when they make sort of, sometimes, in my opinion, disingenuous arguments as to why to bring in these prior bad acts. We all know why we want to bring in the prior bad acts, because you want the jury to do exactly that which they are not supposed to do, which is convict the guy because thinking he's just a bad guy, he's done it before, he did again. That is not what you're supposed to do if you're ever on a jury.
Or where there's smoke, there's fire.
Exactly. But I think it's a dirty little secret that prosecutors try to get this stuff in all the time, just to prejudice your client. Agree?
It is prejudicial, but sometimes it's exactly what it is.
Well, yeah. I mean, I guess the alternate theory would be that it's probative, right? Probative of his guilt in this instance.
Exactly.
Pretty gross stuff, though, that this guy is sort of accused of having. You know, the evidence on his computer, how damaging do you think that is? Remember, he had a file labeled VIX, two of which were had the initials of those victims, Rebecca Blech and Jessica Haringa.
It's very damaging. I mean, in today's world, our life is on our computers and on our phone. On our computers first, and then once the smartphone came into our lexicon, on our phones.
Right.
And you can tell a lot about a person by just going onto their computer and going into their search histories, or just looking and see what type of directories they set up in their file trees. So, yeah, it's useful.
It's certainly useful in this instance. I thought of you, Norman, because I wanted to ask you a question, because we heard in the previous days from this defendant's ex-wife. and she got on the stand to testify about sort of just in general the nature of the relationship, whether or not she was aware of this stuff going on. But I thought, of course, whenever a spouse gets on the stand, alarm bells go off in any attorney's mind, because you think, of course, the marital exemption, there should, that should be privileged communication.
Right.
But then I thought, wait, they're divorced.
Well,
what's the standard?
Well, I think one of the common misconceptions is what the marital spousal privilege is, and it's a permissive privilege, which means that the defendant can't keep his or her spouse from testifying. The spouse has the right to decide whether or not he or she would like to testify.
Ah, I see.
Now that's for privileged communications. Now, if there's some communication between spouses that has nothing to do with the marriage, that's outside of marital conversations, that's not privileged. So, you can't force someone from testifying against you just because you're married to them.
But I would assume that the privilege would cover, even if they're divorced at this point, obviously the privilege would cover that time period during which they were married.
Right, right. It's backwards. It would go back to the marriage. Once you're no longer married, then there's no privilege. And the theory is that husband and wife should be able to communicate with each other about the confidences of their relationship without it being pierced by the outside.
But so interesting. So this defendant, you're saying Willis couldn't assert the privilege from his side and block her from testifying. It reminds me a lot of Jeff Sessions trying to invoke the executive privilege from the other side, kind of saying that President Trump is the one that's sort of invoking the privilege, therefore he is not going to testify before Congress. Anyway, that's a side note. Okay, so we have these prior bad acts. What do you think as a defense attorney? I mean, do you see them having made some mistakes in getting this evidence in, or like how would you try to fend off this evidence?
Well, your strongest defense, if you will, to that evidence is before the jury is in the room, and when you're just having a conversation with the judge and you're making arguments, motions in limine to try to keep that evidence out. And that's where the battle really is. Once you lose that battle, you're stuck.
Yeah.
The evidence comes in, and you have to do the best with it that you can, and and you have to see if you can remind the jury that whatever it is that the defendant is being accused of doing in the past, you have to show that there was no court proceeding, there was no constitutional protections behind the opinion of whether or not he or she is guilty of what's being put forward. So, it's difficult. The big battle is before the jury.
Well, I say all the time here that the battle is really waged and won or lost in motions in limine, in these pretrial issues, because the evidence makes up your case or not your case. And I want to segue a little bit here into the Lewis Toledo trial, because we're on verdict watch there.
That's right.
I thought we would have maybe had a verdict by now, but apparently not, because I really feel that I think he's going to they're going to return a verdict of guilty on all of these charges. But interesting, we mentioned these pretrial motions in limine, because so interestingly in this case, the defense attorney didn't mention this confession. And in openings, the defense attorney never mentioned the confession tape that jurors eventually saw. And we've come to find out that it's because they were arguing throughout the duration of the trial up into the time that they showed this confession to keep it out. Now, in my mind, I'm thinking, if you're a defense attorney, I mean, that's a huge piece of information you want to have settled before you decide whether or not you're going to trial or not. I think you want to know whether or not a admission of guilt by your client is going to be shown to the jurors. I mean, what's your thought?
Well, you know that before the trial starts.
Well, he didn't. Apparently, he didn't. Apparently, he thought that he could keep it out. He went to trial with it being an open question, basically. So he didn't address it in his openings.
That's interesting. Well, not addressing it in his openings is no big deal. I mean, the more you talk as a defense attorney, you're probably hurting yourself. You probably shouldn't open at all. You probably should just shut up and sit down. But as far as not knowing what's going to happen with an oral videotape statement, I assume, is a little strange.
Yeah, that's what I thought.
I mean, usually you'll have a pretrial hearing before. And I mean, unless there was some ruling that is going to go, it's going to waver in the other direction, and he didn't know that that was going to happen, which I doubt. That's a tough one to explain.
I agree. I was really confused by that, but we did see that it looks like a lot in sort of these housekeeping issues.
That's huge.
It's huge. It's huge.
I
It's
mean,
absolutely
look,
huge.
I could think of about the last 3 or 4 cases I've tried. If my clients kept their mouth shut and didn't talk to the cops, they would have beat every single case.
Yep.
Would have been no case against them. And a lot of times that is what the case is. It's the person spilling their guts to the cops.
Yep.
You know,
And
for whatever reason.
Yeah.
You know, whether it's a come to Jesus moment and it's cathartic and you feel better about yourself, or you think you could talk and you can outsmart people. Whatever the reason. It tends not to work. People kind of glance over, you have the right to remain silent. How they miss what silent means, I don't know.
Right.
And anything you say will be used against you. They forget that as well.
Right.
It's amazing.
Right. Toledo, of course, was interviewed extensively by police investigators, and the jury was shown many hours worth of that investigation. And this really, unlike a lot of other times we see here on the network, defense attorneys may try to argue that perhaps a confession was coerced. We hear a lot about coerced confessions these days.
Right.
That the fact that it is true that, contrary to sort of your intuition, people will admit to performing crimes that they actually did not commit when they are under the enormous stress of police interrogation. However, this really wasn't that type of situation. Nothing in the hours of investigation video of Toledo would lend itself to be characterized this investigation as sort of breaking his will or against his will or something that would take it into the territory of a coerced confession. By all accounts, this was a voluntary confession, but we also saw he tried to commit suicide during one of those interviews. What do you think? That's been an interesting evidentiary question. The judge allowed that in, and I don't know if that was the right call. What do you think?
I don't think so. It sounds like he's letting it in as consciousness of guilt.
Yep.
And an innocent person can try to kill themselves just as much as a guilty person. So to let that evidence in as consciousness of guilt is a bit problematic.
Yeah, I agree with you. Now, do you think it's problematic to the point of, it could be,
Yeah, possibly.
You do?
Yeah.
So take us through what would what would, as a defense attorney, what would you do procedurally then, should there be a conviction in this case?
Well, before the conviction, the first thing you have to do is make sure that you make a record and you object to the information. Because if you don't, then the appellate division will probably look back and say, well,
you didn't
defense
preserve the issue.
You didn't preserve the issue, you didn't protect the record. So if assuming that the attorney has done that correctly, then that's pretty much the issue that the appellate lawyer would write about. The fact that this information came in and it was prejudicial. It gave the jury the impression that this is a sign of the defendant's guilt, when there are just as many innocent reasons that point to not guilt.
Right.
So.
Yeah, I agree with you. I mean, the guy just lost his wife, her 2 children. I mean, in playing devil's advocate, if he didn't commit this crime, he's under extreme amount of stress. He's been interrogated for many hours. I agree. Just because he killed himself doesn't necessarily indicate a consciousness of guilt. But now, what would the standard be for them to rule that a mistrial for letting that evidence in? It would have to be
just too harmful an error.
Too harmful.
That there was just no way that a jury would think that evidence showed anything but guilt.
Right. And I think
it's just it's not probative.
Yeah.
And it's very prejudicial.
And it's a high hurdle, obviously, to meet, because I think the assessment of the appeals court would be whether or not there was enough evidence without this piece of information, which was, tainted, to convict. And I think here, there probably is. I mean, what do you think? I mean, just, not taking off your defense attorney's hat, you're in that jury, what are you thinking?
I mean, after listening to those text messages and the phone calls back and forth, and I'm sorry, and how could you do this to me, and I'm sorry, and it just, I think in very weird way the text messages and the phone calls almost build into the crescendo, which is the unfortunate event at the end.
Yeah, we heard in the prosecutor's closing argument there, of course, we all know you don't need a motive to prove as an element of the offense, but here, boy, do they have a motive. And they really laid it on thick that although Yesenia Suarez was having an affair, that doesn't merit death.
No, it doesn't merit death, but it's a common cause.
It is a common cause. And it's almost textbook. We heard that, I don't know if you listened to the 911. Yeah, textbook crime of passion. What do you think about the charging issues? Remember, they charged second degree for Yesenia Suarez, but first degree for the children. Why do you think they did that?
I think, well, for one, they're kids. Two, there may be a reason, or it's not a reason that we accept, but there's at least some logical reason why he killed her. But there's really no reason to kill the kids.
Right.
And I think that in our minds, it's just more egregious, for sure. And although people I think the average state legislature has carved out some leeway for people to commit crimes of passion and not be executed or subject to the death penalty.
Right.
But, the kids almost get killed as like collateral damage almost. And it's just so sad that their lives are taken away because of the actions of what's supposed to be the mother's actions.
It is.
Which still not enough to justify a death sentence, but it's just so sad. It's just so sad, so heartbreaking. And
it's 2:02, guys. Court was set to go back in session at 2 p.m. and we are hearing that Kevin Bloom, remember that's the cousin of Jeffrey Willis, he has in fact entered the courtroom and he has invoked his Fifth Amendment right against self-incrimination. He will not testify in this trial. This is a big deal, guys. Big deal. The defense is saying that they want to enter a 15-hour police interview with Bloom. And they're saying that this statement is going to help show that he was involved in the murder of Rebecca Bletch. Remember, this has sort of been teased throughout this trial. We've always heard about this sort of peripheral character that is the cousin, Kevin Bloom. Remember, he lied to investigators. He was charged with lying to investigators and an after-the-fact offense. Well, now, in the defense's case, we are seeing him take the fifth. No stream yet. We will take you there live when we get to it. But until that time, I want to take you guys to a clip. Remember, we're talking about Jessica Haringa's disappearance, not the victim in this case, but it has to do with his prior predilection for doing this kind of offense. JW25 is Joel Hokisima. And it's a 911 call. So take a listen and we'll bring you live to the courtroom when we get there.
Please raise your right hand. You swear that testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Have a seat. State your name for the record.
Joel Hooksema.
Good afternoon.
Hello.
I want to direct your attention to April 26, 2013. Were you on duty that day?
I was.
And I should say probably around the 11 o'clock hour. I apologize. Were you on duty around the 11 o'clock hour?
Yes.
Yeah.
Yes.
You recall being dispatched to the Exxon station off of Sternberg.
I do.
Now, initially the dispatch was for what reason?
Suspicious situation. There was nobody there.
Okay. And that Exxon station, is that located here in Muskegon County?
It is.
Now, when you got there, do you remember either running into or talking to a gentleman by the name of Craig Harpster? I don't know if you saw him or not.
Honestly, I didn't really speak to very many people while on the scene. I was just dealing with the scene.
Fair enough. Fair enough. When you walked inside the store, Corporal, what did you see?
All the lights was on. All the lights in the store were on. Music was playing. Everything was normal. absent, everything was normal with the exception of no employee on scene.
Okay. I'm going to show you here some photographs. First photograph is People's Exhibit 28. What are we looking at here?
That's the back door of the gas station from the inside looking.
And is that kind of how it appeared to you that particular night?
It is. It appears in this photo that the door is propped open slightly. As I recall, that night when I responded, the door was closed.
Okay. Now, did you notice or observe any signs of a struggle or any of that, any disturbance, anything disturbed?
No.
The next photo is People's Exhibit 29. What are we looking at in that photograph?
That is the cash drawer sitting on top of a safe, kind of in a back room area of the store.
Now, is this particular Exxon or this particular gas station, is it a 24-hour gas station, or does it have an open and closed time?
It has an open and closed time. It wasn't open 24 hours.
And do you recall at all the time it closed at night?
I don't know the time it closed. I don't remember.
Now, this drawer, I guess, and I don't know if you were asked to, but did it appear as if any of that money had been disturbed at all?
It looked normal to me, as it does in the photo there, just as an employee would use it. Nothing appeared to be rifled through. There wasn't bills sticking out at odd angles or anything like that.
All right. Now, outside of that, did you discover any personal property?
I did.
What was it that you discovered?
I found a purse and a jacket in that back room area as well.
So this is People's Exhibit 30, kind of more of an expanded view of the back room. Is that safe to say?
Yes.
And I see there's a coat in this picture. Is that the coat you're talking about?
Yes, the purple coat hanging on the shelving unit there.
Did you happen to determine or find out, or did that purse contain any identification?
The purse sitting on the boxes there, we determined belonged to Jessica Herringa.
And do you recall, did that purse have any personal items in it?
I personally didn't open the purse, and I don't recall. I mean, I know it was determined to be Ms. Herringa's, but I don't recall specifically how.
Fair enough. Any other personal property?
Not that I recall.
All right. Outside the station, People's Exhibit 31, what is this a photo of?
Looks to be a photo of a Mercury sedan.
Do you know this to be the car of Jessica, or was it determined to be Jessica Herringa's car?
I don't know that. My area was in the back of the gas station. I didn't deal with any of the cars up front.
Okay. Fair enough. Let's talk about the back. You indicated that, or maybe you didn't, but is there only one door that gets you from the inside of the store to the back of the store, or outside the back of the store?
That's correct.
And what are we looking at in this particular photograph, which is People's Exhibit 31?
32.
32.
That's the back door of the gas station that we had previously identified looking from the inside. This is looking from the outside.
And Ms. Follett had testified that that door kind of splits the store in two. I mean, it's halfway on either end. Is that what you recall?
Yeah, that would be accurate.
Okay. Now, did you find anything of particular interest in the back?
I did.
What was that?
Multiple items, including 2 small batteries, a battery cover for a laser sight, as well as some blood.
All right. We'll get to that here in just a second. This photograph, People's Exhibit 33, is, what are we looking at here?
The back of the store again, looking towards the west. The back door can be seen right on the left side of the frame of the picture.
And I don't, can you see in this particular photograph the laser sight cover?
Yes.
You got a stick in front of you, a pointer. You can point it out.
It's this little black shape right there.
Okay, and I know the batteries are quite small, and I don't know if you remember in relationship to the laser sight cover where the batteries were found.
I can't say with absolute certainty, but they're in the general vicinity of the battery. I mean, they're so small that I don't know if they would show up in the photo.
Okay, fair enough. Let's look at People's Exhibit 34. What are we looking at in this particular?
It's a closer up photo of the items that I had found, including the battery cover, the batteries, and the blood.
All right, if you could point out all of those, please.
The battery cover right here, you can see the white label on it. One battery right there, second battery right there, and then the blood.
Okay. Now, could you describe for the, and I'm assuming, Corporal Hoeksma, that did you collect those items?
I did.
And could you describe for the jury how you collected the blood, please?
I used essentially a long Q-tip, little cotton swab on the end. We wet the blood with some purified water, swab the Q-tip in it, and then take the Q-tips and package it in very small evidence boxes, which ultimately gets sent to the lab.
All right. Start with People's Exhibit 161. Could you describe what's in that package, please? It's not open.
Oh. It's laser battery cover.
And that's the, in that package contains the laser battery cover that's in the exhibit, in that photograph.
That's correct.
162.
2 watch batteries.
And again, that package contains the 2 watch batteries that are in this photograph that's being displayed right now, People's Exhibit 34.
That's correct.
And finally, 163. Is that the blood stain?
Yeah, we have two packages. Top one is 3 blood stains, and then the bottom one says toothbrush belonging to victim.
And that is, as you described to the jury, taken from that blood stain found at the scene.
Correct.
All right. Now, I believe, let's check here. We'll look at People's Exhibit 36. That is, what are we looking at in that photograph?
That's the battery cover from the laser sight.
And does it indicate a potential manufacturer?
Yeah, it does.
What's that?
Carl Walther.
Okay. And do you recall doing any investigation on that?
Essentially, I just did an internet search of that product,
All right.
and
Discovered what?
that it was a laser sight made specifically for a Carl Walther pistol.
Okay. And any of those numbers on there allow you to tie it to any specific particular laser sight or handgun that you're aware of?
I don't recall any specific, just that it was specific to that manufacturer of handguns.
Okay. Thank you, George. I have no further questions.
Hey, Mr. Johnson, any questions?
I do.
Good afternoon.
Hello.
I'm Fred Johnson. A couple more questions, if I may. In the photographs that we saw of the back of the store, the lights are on. Is that the condition that you found it on the night in question?
Yes, as I recall, the lights were on.
Okay, and you did not, you know for sure you didn't turn them on?
That's correct.
Okay, and also in the back of that store, it appears to be a gray door. Do you recall? Would you put up 31 or 32? There you go, a door.
Yes.
You see that? You see the door I'm referring to?
Yes.
Does that door have a door handle on the outside?
It does not.
Okay. I see it's open there. Did you open that door and come out through there, or did you walk around the building?
I went through that door.
Okay, so there's a handle on the other side.
There's a crash bar to push open, yes.
Oh, one of the bar that goes along?
Yes.
Okay. Do you know whether or not that door locks when it's closed?
Well, I'm not certain if it'd be locked. I mean, I know you had to actuate that bar to open it.
So a person would have, so I couldn't just push it open from the outside. That bar has to be actuated on the inside, is that correct?
Correct, yeah, you'd have nothing to grab onto on the outside to pull it open.
And nothing to trigger the unlock switch from the outside?
Correct.
There's no keyhole or anything back there? That you
Not that I recall, and I can't see anything in the photo.
Okay, and as you recall, all those lights were on, and just as they are here.
That's correct.
Corporal, during that night, this was, what day was this again? June?
April 26th.
April 26th. On that night, April 26th, do you recall, did anyone in your presence mention the name Rebecca Bletch?
No.
Thank you. I'm no further questions.
Before I excuse the witness, Judge, I would move to admit exhibits 161, 162, and 163. 161 is the Walther laser sight cover. 162 is the two watch batteries. And 163 is the bloodstain evidence.
No objection, Your Honor.
Okay, now I don't have 158,
I know.
59, and 60.
I'll get
Correct?
there.
Okay.
Yep, I'll get
Just
there.
want to make sure we're on.
Yes, sir.
All right, we'll admit then 161, 62, and 63. Thank you, officer. You may stand up.
You're watching the Law News Network, everybody. Aaron Keller along with you for the afternoon hours here, along with Norman Williams, who's standing by to provide some analysis here. Here's what's going on in the Jeffrey Willis case right now in Muskegon, Michigan. The judge and the attorneys are continuing to have an argument outside the presence of the jury about the defense's case in chief. The defense wants to play a very, very lengthy recording of an interview with the defendant's cousin. Now, the defense is claiming that in that interview, there is some evidence, in the defense's view, that the cousin was involved in the murder of Rebecca Bletch. That's whose murder the defendant, Jeffrey Willis, is on trial for right now. But the judge has just said a couple of minutes ago, ultimately, that there's no evidence in the judge's opinion that Kevin Blum, the cousin, was in any way involved in Rebecca Bletch's murder. Now, we're not able to stream audio of this proceeding because it's outside the presence of the jury, and the judge has decided that if it's outside the presence of the jury, it shouldn't be streamed. But we're hearing from those in the public gallery in the courtroom what's going on. Of course, it is a public proceeding, even though it's outside the presence of the jury. So we're jumping through a couple of flaming hoops here to try to bring you the information as best we can. Bottom line, that's where things are going. Now, Norman, I'm kind of curious about this. The defense says it's evidence that somebody else is involved. The judge, there's no evidence that somebody else was involved. So, you know, I know this is a civil law construct, but if there's a difference of opinion, doesn't it create a triable fact for the jury?
I would think so. I mean, and to be honest, I understand he took the fifth when he got on the stand, right? Mm-hmm. Oh, I'm happy as a defense attorney because now I get to say all sorts of things in my closing about why this person would not be honest with the jury, that he had something to hide, that he felt that if he ran his mouth, he was going to subject himself to criminal liability. That is a gift for the defense.
It is.
It could be better.
Well, certainly.
But it's a gift.
I would agree, you know, but is it is it arguable then, in the prosecution standpoint, that the reason he's taking the fifth isn't so much with relation to the Rebecca Bledge case, but in relation to the Jessica Herring case, which is the other case where he admitted ultimately that he had helped hide this other murder victim's body?
Now that is possible, and then it's not a gift anymore, and then it becomes a witness that you really want to stay away from, that you don't even want to walk into the courtroom. You know, but I guess from the prosecution standpoint, they're erring on the side of caution, that if this other information comes out, and if it's inadmissible information, then it would they'd be subject to a mistrial and they'd have to start all over again.
I'm curious as to your opinion about this process, because this has been an interesting case. Now, in essence, we're in court in Muskegon, Michigan today, related to the murder of this young mother named Rebecca Bledge, okay? But the state has been able to successfully present evidence about the Jessica Herring murder in this case.
That's a prior bad act, right?
Yes, and also about the attempted abduction of this 16-year-old who ultimately led police down the road of going after this particular defendant who's on trial, Jeffrey Willis. So, you know, it's rare that we see a case where all of these prior bad acts come in. And my guess is that the reason that the state was able to ultimately do it was because it sets up a, you know, pattern of behavior, motive, opportunity, that sort of stuff. A lot of judges are really hesitant to do that, though.
Well, they are, but only for appellate reasons. But as long as the government presents the evidence under the correct standard, then there's no problems as far as a judge is concerned. But I think that the average judge is just kind of wary of the fact that stuff like that is prejudicial. And if the accusation has been lodged, but there has been no court proceeding and no constitutional protection around that accusation, then I think a court will be a little careful to not prejudice the defendant.
Yeah, so we're waiting to see exactly where this argument goes. I'm not quite sure from the information I'm getting out of court if the judge ultimately ruled that this recording is irrelevant and therefore can't come in, or if the judge just said that it doesn't necessarily present evidence that the cousin, Kevin Blum, was somehow involved in the Bledge murder. Still kind of waiting to see what the ultimate upshot of this argument is. But at last word that I had, they're still at it in court. In the meantime, we're going to continue to listen to some of the previous testimony in the case in case you've missed it while we were covering the Toledo case. By the way, the jury there is still deliberating. This is testimony in the Willis case from Corporal Christopher Hare.
Myself and another investigator, and we would follow up leads, talk to the people, and then we would document what we had found.
Now, let's talk about that documentation process. Did you actually, now, for those who don't know, is there an official way to write a police report and document an official police report?
In our county, it's called the RMS system.
Okay. And when you received these tips and you did your follow-up investigation, did you go to the RMS system and type a police report?
I did not.
Why?
Because the procedure for this specific case was unique, and we followed a different protocol.
And that was followed by all the investigators that were following up on tips?
Yes.
Now, you didn't just talk to somebody, commit it to memory, and move on, did you?
I did not.
What did you do?
I received the tip sheet that had the information that was provided through the tip line. Sergeant Baker and I went and followed up the leads. We took notes from an interview that we completed or area we looked or searched, and we turned in the tip sheet into a basket in the command center.
Now, was there somebody assigned then to take those notes and do something with them?
There was.
And what was that responsibility?
They would they were put in a basket. They would eventually take them out of the basket, and they would enter them into a computer system.
Now, the reason for the computer system was what?
To collect the data.
All right. Did it make it easier to search? If, for example, let's say in tip 100 gave you you talked to somebody, and then at tip 300 there might be a connection to tip 100.
Correct.
Is it easier to do it via paper or via computer to match it up?
It would be, if it was all compiled in a computer system, it'd be easier to search.
And was that the point of doing it that way?
Yes.
All right. Now, so just so I understand, every tip that you investigated, you took notes on, you documented, and that was turned in to be entered into a computer system.
Yes, it was.
All right. And was that the process done for every single tip that was received on the Jessica Herringa investigation?
That was the protocol, yes.
All right. I want to talk to you about a specific tip, tip 268 that you received. I'm handing you what's been marked as People's Exhibit 166. Can you describe what that is, please?
This would be a typed version of the notes that I had written on the carbon copy tip sheet that I had received upon going out to do my investigation.
Okay. And what date did you receive that particular tip to investigate? Do you recall?
I don't recall the exact day that I had the tip assigned to me. I do know the date that I actually had contact with.
All right. That's a better question. What date did you go out to investigate that particular tip?
I investigated that tip on May 7th of 2013.
Okay. So approximately a week and a half or so after Jessica's disappearance?
Yes.
Now, the nature of the tip was what?
The nature of the tip was there was a gentleman that drove a silver van. He was frequenting a local business. He wore a red sweatshirt, and he seemed to act odd to the employees of the local business.
All right. And when you received this tip, did you have any idea who this person was that you were going to talk to?
No idea.
Ultimately, did it tell you where you were going to go to try and find this person?
Ultimately, through my investigation, when I went to the business, it did lead to where I was going to find the person I was going to interview.
All right. And who was that person going to be?
That would be Mr. Jeffrey Willis.
And did you end up meeting up with Mr. Willis?
I did.
And where did you meet up with him?
At his home.
Which was where?
I believe it was 1842 South Sheridan, or Sheridan.
Okay. And when you arrived at 1842 South Sheridan, did you observe, well, what did you observe?
Sergeant Baker and I were assigned this tip, and after leaving the business, we drove to an address that I came upon for Mr. Willis through a computer search in our RMS system, and I observed a silver van parked in the driveway.
Now, at this time, was Mr. Willis even a suspect in the disappearance of Jessica Herringa? I mean,
No.
Was he, any more than a person of interest?
I wouldn't even qualify it as a person of interest at that point.
Okay, just following up on a tip.
Correct.
Now, were you able to make contact with Mr. Willis on that particular date, May 7th?
Yes.
Okay, and where did you talk to him?
At his front door on the front porch.
Okay, did you stay at the front porch? Did you go inside, or were you outside the entire time?
Outside on the front porch the entire time at the door.
Okay. What information, if any, did you get from Mr. Willis that particular day as it relates to the disappearance of Jessica Herring?
As I spoke to him, I found that he was at the Exxon station on East Sternberg on the date that she disappeared.
Did he indicate what time he was there?
He said he was there at about approximately 5 p.m.
And did he indicate at all whether or not he knew Jessica?
He said he does know her. He did know her.
Okay. Now, except for that 5 p.m. hour, did he indicate where he was the rest of the day or night?
He did.
What did he say?
He told me that he was at the Exxon station at approximately 5 o'clock. He bought mints. He might have been there for about 3 minutes. He talked to Jessica on that date. He left there and he went to a card shop where he played some card games. I believe he said he was at the card shop until about 9:30 p.m. And he left the card shop and he drove to his home on Sheridan, and he arrived there about 9:45 p.m. and he stayed there until 12:30 a.m. the next morning.
Okay. And did he indicate to you whether or not he stayed at the residence after that 12:30 hour or left the residence?
He said he left the residence.
And did he indicate where he went?
He said he went to his grandfather's home on Bailey in the city of Norton Shores.
All right. And did he indicate the purpose of making that trip at 12:38 a.m. on the, I guess would be the 27th?
Correct. He said that he went to his grandfather's house to retrieve a board that he was going to use to repair or build up his dog kennel at his house.
Now, were you able to talk to anybody else at Mr. Willis's house that day?
No.
Did you ask to talk to anybody else?
I asked him if he was home alone, if anybody else was at the home.
And his response was?
He said he was home alone.
Were you aware at the time that he was married?
Through the conversation with him, I learned that.
Okay. Mr. Willis told you that?
Yes.
Okay. And I don't know, Corporal Hare, if you asked at that time, did you ask at any point to talk to, or whether or not his wife was home, or that if you could talk to her?
In the investigation, yes. I said I would like to speak with her.
And what was the response to that request?
That would be fine.
All right. But could you talk to her that day?
No,
Was there a reason given why?
she wasn't there.
All right. Now, did you also, as part of what you were investigating, did you ask permission or seek consent to view any cell phones or any of that nature?
I did. I asked him if he had his cell phone with him.
And what was his response to that?
He said that he didn't have it with him, that his wife had it with her at the time.
So were you able on that day to get a cell phone from him?
I was not.
Now, did you also get an opportunity to inspect the silver van?
I did.
And can you describe for the jury what you saw or what you didn't see?
As we went to the van, Sergeant Baker, I, and Mr. Willis, we walked over there. He opened the van up, both the back hatch portion of the back of the van, as well as the side doors, and the van was empty, entirely empty. And it was actually clean, and to the point where it had vacuum marks on the floor. He said he had just had it detailed.
Okay. Anything, I mean, at that point, Corporal Hare, did you see anything, find anything, or notice anything suspicious that would cause you to look any further?
Nothing whatsoever.
Now, at some point in time, well, as we fast forward to 2016, did Mr. Willis become more of an interest?
He did.
And as a result, what did you do as a basis for your tip?
I was given this exhibit and instructed to write a RMS version of a police report.
All right. Any difference between what you first observed in 13, wrote down in 13, was typed in 13, to what your report reflects in 2016?
No.
I'm assuming that you were able to go back to the computer system and grab the original tip that was typed out.
It was provided to me. I didn't actually do it myself.
All right. But was there anything different that you recall?
No.
Now, at some point in time, Corporal Hare, did you attempt to call to try and talk to Mr. Willis's wife?
I have learned that I did do that. I do not recall that.
All right. I'd like to play something for you, if you don't mind. First and foremost, is that your voice?
That is my voice.
Your Honor, reference your approach.
we've got it identified. I will play it back.
Here, I'm short we'll do an investigation. I spoke with the chef on it a while back, probably, I don't know, a month ago or something like that. I'm wondering if there's any way that we could speak with you, or if I could come to meet you, or you could meet us at the police department, it's probably half hour or something like that, just to solidify some things up and clear this up so that we can close this portion of our case and move on. So, it's good. Just call me. This actually fits please. The easiest way to get a hold of you, phone number is 733-2691. Recognize Corporal Hare, H-A-R-E. I want to stay until probably 4 o'clock. Today is the 3rd of June. I appreciate the call back. Thanks.
Now, did you ever receive a phone call back from anybody purported to be Mr. Willis's wife?
Not that I recall.
This is Corporal Hare, Trust Police calling you back. We did some more investigation stuff, and I don't think we will need an interview from you unless you have something to tell us or any information you want to pass along. We kind of worked our way through and figured it all out without even having to speak with you. So unless you have anything else to add, we don't have to speak with you unless you want to speak with us. If you have any questions, we'll try and get in touch with each other. And Corporal here in our Trust Police. It is 8:30 on the 6th of June, Thursday.
That was the second phone call. Was that your voice again?
It was.
And did you ever receive a return phone call from anybody purported to be Mr. Willis's wife after you left the second message?
Not that I recall.
Okay. The person that you talked to back in May of 2013, is that person in the courtroom?
He is.
Could you point him out and describe what he's wearing, please?
He is seated at the defense table wearing a suit with a blue tie.
Now let the record reflect the witness has identified the defendant.
It will.
Nothing else, Judge. Thank you.
Mr. Johnson? Thank you. Good afternoon, Corporal Hare.
Good afternoon, sir.
How are you this afternoon?
Some previous testimony in the Jeffrey Willis case out of Muskegon, Michigan there from a Corporal Christopher Hare. Now, here's what's happened in the last couple of minutes in the Willis case. The judge has ended the proceeding for the day, and here's why. We heard earlier that the defense was trying to put into evidence this lengthy interrogation recording of the defendant's cousin, trying to claim that that cousin, Kevin Bloom, has somehow involved in the murder of Rebecca Bletch. The entire recording is apparently 18 hours long. And initially the judge said, hey, look, I don't think there's any evidence in there that this cousin was in any way involved in this case, but the defense wants to get it in, and the judge said, okay, if you're really adamant about this, we're going to have to delay the proceedings and take time to go through it bit by bit and see what's in it. So the trial, Norman, is delayed at this point.
Yes.
While they try to go through this. My first question was, if I were a defense attorney and I had this thing that was that long, I would want a transcript, I'd want edited pieces of it and say, Your Honor, under the rules of evidence that suggests that the entire depth and breadth of any piece of evidence be submitted, we're asking that the whole thing be played for the jury. In the alternative, these are the most critical parts we want in, and this is why they're relevant, and I'd have them ready to go. So why, at this point in time, are we slamming on the brakes in the middle of this proceeding?
Well, I can understand why the judge is frustrated. This is something that could have been dealt with before a jury was even selected, or it could have been dealt with before the trial began, after the jury was selected. You know, you have a tape that's 18 hours long, so you need to watch the tape. I assume the defense has already done so. Now the judge is going to want to sit and watch it, and 18 hours is a whole day gone. The trial's not moving. At the end of the 18 hours of viewing, now the question of, are there portions of it that need to be sanitized for evidentiary reasons, one way or another? Now you have your tech guy has to spend time editing an 18-hour block of information. It takes time. It delays the trial. Jurors don't like to be delayed. Judges don't like trials to not move forward. And it's a bit of a mess. And at the end of it, it might not even help the defense at all. And it might just be the attorney trying to slam on the brakes and slow the trial down for a brief second.
Well, what would be the tactical reason beyond that? I mean, normally we have rules of evidence to try to weed out undue delay. Okay, the rules of relevancy ultimately are for this point.
Exactly.
If the evidence doesn't nudge your case just a hair one way or the next, it's not in. We don't waste our time considering it. And there are other rules that say if it's cumulative, if it's just going to result in a waste of time, we don't get into it in front of a jury. But yet here, we have an abrupt halt. They might not be back into session until Tuesday, if that. It might be delayed even beyond Tuesday, we're hearing.
Because I'll tell you what else is interesting. If the cousin was his co-defendant and they were at trial together, then there probably would have been some severance issues because of the two alleged confession videos. And one co-defendant's video statement can't be the sole bit of evidence towards the co-defendant. So what would happen is, let's say in the 18 hours he spends 5 hours talking about Willis. That 5-hour block would be sanitized, would be edited from the tape. So it's kind of strange. It does seem a bit strange that the defense brought this up now. And this is after the cousin has testified and took the fifth, right?
Yeah, and apparently they're thinking about potentially dragging him back in next week and enforcing the whole charade all over again.
Right.
So that's another interesting development. I'm really interested now what's in this recording, because it's either something or it's nothing.
Right. It either helps or it doesn't.
Yeah.
And you know what? It actually may help. The information that the attorney is seeking to place on the record might be the responses to the questions that the witness would not answer.
Now that would be interesting. It of course requires the drawing of a number of inferences, but
of course.
The silence may potentially point to something.
Right. So there may be something there. Who knows?
We are hearing that there may be a question from the jury in the Toledo case in Florida that we are also covering here on LawNewz. That's a case that perhaps you've been following along with us, where a father in Florida is accused of killing his wife and her 2 children, ages 8 and 9. The jury had some other questions this morning. They're apparently trying to piece together their own timeline of what happened, but we here at LawNewz have been talking about it quite extensively. I wonder whether the jury just didn't hear it in quite as succinct a fashion as we've been trying to lay it out. So we're waiting for the court feed to come up in that case. Apparently the attorneys are in the process of coming in. Another question from the jury here. They seem to be really honing in on what's going on here, but the timeline, as I understand it, is this. October 22nd, there's an altercation at work. The defendant had ultimately discovered his wife having an affair. He had rumblings, he had intuitions, and then he ultimately installs some spyware on her phone to try to catch her. He confronts her at work on the day that he believed his wife was ultimately going to go off and have a tryst with her lover, who she met at work. Confronts her at work, ultimately winds up hitting her in the face. There's no independent witness to it other than the wife, but she did tell police about it. She tells police on October 22nd, 2013, that he had previously threatened to kill her, said how he would kill her, and just painted a picture of a degenerating relationship. She said he had threatened him with a knife prior to that day, said that he had strangled her prior to that day, said that he had grabbed her and pushed her prior to that day, that she was afraid of him, and she did not want her location disclosed. She was planning to take the kids to her mother's. Well, that's ultimately where she went, and ultimately the defendant wound up finding her at the mother's. They talked. They apparently made a deal to allow the defendant to stay in the marital home until he had the money to move out. At the time he was studying, he was not working. So You know, that's how things kind of went on the 22nd. And then the victim, Yesenia Suarez, made the choice to go back home with the defendant. And the last time she was heard from was at about 1:03 in the morning on October 23rd, 2013. At about 5 o'clock in the morning, the defendant apparently showed up at his brother's house. The brother testified at trial that he just randomly showed up out of the blue, no warning, at about 5 o'clock in the morning, something that's probably out of character for a lot of people, and ultimately started talking about the affair. The brother said that the defendant seemed out of it. Then the defendant goes back home shortly after 6 o'clock in the morning. He taps on the neighbor's window and asks the neighbor to follow him in his own vehicle while he, the defendant, drove his wife's vehicle. The neighbor thought it was going to be a short trip around the corner. It turned out to be a half-an-hour excursion to a neighboring county. The neighbor testified he watched the defendant ditch his wife's car, take the trunk mat and some other items out of his wife's car, get back into his own car, which of course the neighbor had driven, and then they went to an apartment complex, threw the trunk mat and the items into the dumpster, then headed back home. Eventually, the neighbor saw police activity because the victim's the victim's mother had tipped police off that she hadn't heard from her daughter and was very, very concerned given what had happened the previous day. And ultimately, all of this evidence came together. On the trunk mat, we had the blood of the daughter that is believed to have been killed. The daughter's blood was also on the defendant's shoe. And the children's toys and other personal effects were thrown into that dumpster in the apartment complex near where the car had been ditched. The house reeked of cleaning fluid. It's said to have been Pine Sol, so there's evidence that the scene had been wiped down. But ultimately, the defendant is trying to blame the neighbor on the murder of the two children. You see them right there on your screen, Thalia and Michael Otto, ages 9 and 8. Now, the state is saying, look, there's absolutely no motive to kill those kids, at least from the perspective of the neighbor. But, you know, it's one of these cases, Norman, where the state is asking the jury to believe part of the defendant's testimony, or rather statements to police, but not all of them.
Right.
Because the state is saying, hey, look, he admitted to killing Yesenia Suarez, believe that,
Right.
okay, convict him of second-degree murder right there, okay. But the state is saying, believe him when he says the kids were killed because they were witnesses to the mother's murder, but don't believe him when he says the neighbor's the one that did it.
Right.
Now, to me, that seems like a rational conclusion, but it does ask the jury to kind of split the interrogations of the defendant.
Right.
And some jurors might be a little bit uneasy about that.
Right. Well, they'll figure it out. They'll figure it out. I mean, you're right though. I mean, I guess off first blush, it does seem a little ridiculous that the neighbor would get all involved in this story and would want to extinguish the lives of two innocent children. I mean, it just seems crazy, as even crazier.
He doesn't have any motive. And granted, they don't necessarily need to prove
Need,
motive in a lot
right.
of states, but you know, that's what the state is saying. He had no motive to do it. Now, it does make sense the way the neighbor explained it, that he was sleeping and his buddy next door woke him up and said, I need hand moving a car. And he assumed that the neighbor, that is, assumed it was just going to be moved down the block or somewhere nearby. Didn't realize it was going to turn into this lengthy excursion to a neighboring county where the car not only is ditched in a parking lot, but the items are taken out of it, which turned out to have one of the alleged victim's blood. Okay, but then the defendant wipes the car down in the parking lot and the neighbor witnesses it.
Right.
You know, it seems to me that the defendant was just hoping that the neighbor wouldn't snitch on him.
And it also sounds like the neighbor's lucky that he's still here with us as well, because he's a witness also.
Well, that's what it seemed, and that's part of the reason why the neighbor said that this entire excursion back from the location where the car was ditched was just so belabored and difficult. It was uneasy. And at one point in it, the defendant just says, I snapped, and just drops that into the middle of this long car ride where no other words are uttered.
Right. Yeah, it's the weirdest thing in the world. Like, Aaron, I like you, but if you ask me to follow you somewhere or to go somewhere with you, if things look a little squirrely after a while, I'm going to start asking questions, or I'm going to turn around. And you can walk home. I mean, it's unbelievable. I mean, and the neighbor probably at one point was in shock as he's putting things together. And then you feel trapped. And then you're starting to wonder, is my safety in jeopardy? You know,
Oh,
it's
certainly.
It's
I
pretty
mean,
heavy.
it seems like exactly that kind of a case. So we're hearing that the jury has another question. We're waiting to see if we can bring you that question. Apparently, they were going to discuss it in open court. The jury did have some other questions earlier today, and it seems that the jury is at least this morning, had more questions about a map, sort of laying out the whole area, because again, this trial is being heard in a remote location.
Okay.
So the jurors may not be intimately familiar with the area, so
Right.
they probably need the map. They asked for that. They also really seem to want to be putting this timeline together on their own. Now, my fear with that is maybe the state didn't do it well enough in either openings or closings. If the jury's trying to sit there and basically do what I just did and lay out when everything happened.
No, they're going to do that anyway. I mean, it doesn't matter. I mean, openings are heard and then they get forgotten, you know, because the evidence is what's supposed to replace what's in your mind concerning the guilt or not guilt of the defendant. But, you know, I think that in today's world, we're so used to getting responses to questions in such a quick fashion, and we have the ability to get answers to questions that we didn't before, so that to look at a location is very easy in today's world, right? You just pop online and get a map, and then you can kind of understand what you're looking at a little bit better.
Yeah, it seems that the jury did ask for that earlier, but apparently we are starting to get the feed from open court here, where the judge apparently is discussing the jury question. Let's go there live now.
Okay, then what I'm gonna do, Adrian, if you go down there meet the deputies down there, have the deputies tell them to knock on the door and tell them to stop deliberating, go through the evidence, and bring those two exhibits back to the courtroom. Huh? Yeah, meanwhile, let's go ahead and Pete tell them to bring them down here. Did you have these transcripts on a electronic file?
Mr. Will does, I know, Your Honor.
Can you search
Yes,
for the key words that they're looking for?
I will text him right now.
So ultimately what the jury has asked for here is a replay of the interrogation recordings where the defendant was confessing basically to the murder of his wife, Yesenia Suarez. And the jury also wants to listen yet again to the purported suicide attempt. So this is when he asked for yet another bathroom break in relatively quick succession from a previous one. And the investigators who were interrogating him complied and led him out into the hallway. So as the story goes, according to the testimony, the defendant went into a bathroom and he was in a very emotional state at the time. He was sobbing in the interrogation videos. And goes in the bathroom, ultimately barricades the door, breaks the mirror, and tries to kill himself in this very small one-seat bathroom that's around the corner from the interrogation room. The recording equipment in the interrogation room was still rolling, and on the sound pickup from that recording equipment did pick up the sound of the attempt and ultimately the sound of the investigators trying to break the door down to get him out of there. Ultimately, they wound up not getting the door off of its hinges, although they tried many times with a battering ram. They wound up knocking a hole in the door and then tasing the defendant, Luis Toledo, in order to stop the suicide attempt. But there were photos of this attempt showing the bloodied bathroom, the broken mirror, the hole in the door. And the state was able to introduce this as evidence of consciousness of guilt. And Norman, I think it's pretty believable.
Yeah, no, it is. It really is. I mean, it's hard. It's the sort of thing that a defense attorney does not want to deal with, but it is what it is.
I think it was a very, very tough case for the defense. I think the defense did probably as good a job as the defense could do with it, but it's just a mountain of bad facts against the defendant.
This is the truth, a mountain of bad facts. I mean, I said in an earlier segment that I think it's interesting that just listening and reading the text messages, you could just feel in the conversation where things were going to head. That I don't think it's not somebody reading those text messages would not have been far-fetched to think that this guy is going to kill her. And I think this is where this is going. It's going to be a violent end to this conversation.
Yeah, you know, and I wrote a piece that I've talked about many times here on LawNewz before. It's up on LawNewz.com for those who haven't read it. And basically, you know, the question that I had was, Florida is one of the states that does not have a mandatory arrest law in situations of domestic violence. And many states are passing these laws in some fashion or another to try to prevent this from happening. If there was a mandatory arrest provision, he probably would have been arrested on the 22nd, would not have been out walking the streets freely on the morning of the 23rd when the alleged murders were said to have happened.
That's possible, I said, but on the other hand, sometimes a mandatory arrest makes things worse. Sometimes.
It looks like we may be back in court with some more discussion now. It's a little bit hard for me to hear it, but I want to listen in to make sure we're not missing anything.